Hi there, this is Jonathan Ginsberg. I'm an Atlanta area personal bankruptcy attorney. And today I'd like to answer a question that I got from somebody actually up in Gainesville, Georgia. And that is, can I file bankruptcy and protect my boat? In Gainesville, there's a lake up there, Lake Lanier, where people have boats, and sometimes they want to protect their boat when they file bankruptcy. And the answer to that question is maybe. The reason I say it that way is that most of the time a boat is not necessary for financial rehabilitation, so it's considered kind of a luxury item. So obviously if it's a houseboat and you live on the boat, that's a different story. But if it's simply something that's recreational, if you file Chapter 7, you could try to reaffirm the boat. You might find some resistance from the trustee or creditors saying that the money you're using to pay off the boat is something that money could be used to pay creditors. Now, you can get past that sometimes if you show that the amount remaining on the loan is relatively small and that giving up the boat would cause economic harm to you. So, for example, if you had a boat that was mostly paid off, you could shelter whatever equity you had and you wanted to reaffirm $2,000 or $3,000, you could probably get that through. If you have a boat where you owe $45,000 on it and you're paying $800 a month, probably not. So it really depends to a certain degree on how much you owe on the boat, what the monthly payment is, and kind of the status of your loan. Chapter 13, it's probably less likely because, again, Chapter 13 is really looking a lot more at disposable income. And I think it'd be a very hard argument to make that you need a boat for your financial rehabilitation, again, unless you use the boat to earn money or you live on the boat. So simply for recreational purposes, I think it's going to be difficult to keep a boat unless in the Chapter 13 you're paying at 100% to all creditors, unsecured creditors, or maybe even 80%. But if you're going to go into a Chapter 13, pay your unsecureds at 5 cents on the dollar, and you want to keep a $30,000 boat, it's not going to fly. So big picture here is if you have a boat and you think you need to file bankruptcy, talk to an attorney early. Let's talk about what the options would be. Maybe selling the boat would be something to do. But as a practical matter, this has got to pass the smell test. And like I said, if you're not living on the boat or you don't use it to earn money, it's a luxury item, and bankruptcy courts are not real fond of letting people keep luxury items if they're not paying back their creditors in full. So that's my take on keeping a boat when filing bankruptcy. I hope you found it helpful. If you did, please give it a thumbs up on YouTube or a like on Facebook and subscribe to our channels. If you have any questions about this or anything else relating to personal bankruptcy, please reach out to me. I'm Jonathan Ginsberg, and I'll talk to you soon.